beginning any event, we offer our prayers to Ma Saraswati, the goddess of wisdom, and light a lamp to help illuminate our path forward. I invite our Chief Guest, Justice S.C. Dharmadhikari, and our Principal, Dr. Srimati Asmita Advaitvedya, along with our panelists for the day, to light the lamp and provide us with an auspicious start to our event.
It is an honor to request the Principal, Dr. Asmita Vaidya ma'am, the Chief Guest, Justice S.C. Dharmadhikari, and the Professor in Charge, Assistant Professor Dr. Anita Desle ma'am, and Assistant Professor Dr. Shweta Shiraskar ma'am, to kindly grace the stage with their presence. And also, along with them, our Professor Kishu Daswani sir.
Every institution is guided to greater heights by those at its helm. At GLC, we owe a debt of gratitude to our principal, Dr. Asmita Vaidya, for the same. She completed her PhD in 2006. Since then, she has provided us with her able leadership and decades of experience. In the span of her career, she has authored 8 reference books, 40 research articles, and more than 100 articles on women's rights, which have been published in various national and international newspapers and journals. She has also been the recipient of several awards such as the Tejaswini Award, Nation Builder Award, Navdurga Award, Superwoman 2020 Award, and the Best Teacher Award for 2020. With this, we would like to invite our esteemed principal, Dr. Asmita Vaidya ma'am, to say a few words.
Ma Saraswati Lavandan. Today's chief guest of 9th policy debate, Honorable Shri Justice Satyaranjan Dharmadhikari sir, former Justice, Bombay High Court. The panelist, Advocate Abha Singh, Mr. Anil Gawande sir, Dr. Shaikh, Dr. Shah, Advocate Raju Ramachandran, Advocate Suraj Sanap sir, all the professors who are present here, and my dear students, very warm welcome to this Government Law College, Mumbai. Today, we gathered here to discuss on very vibrant issue, which is really a challenge before the society. The concept of marriage has been accepted throughout globe. No single society on the globe exist without the union of two different sexes under the legal bondage named marriage. We consider marriage as a form of sacrament for the social cause and having scientific union for procreation of next generation. It is of course the union of two different sexes. But today, society has started talking about the marriage equality, that too union of same sexes. There are many questions emerged in the young minds. Firstly, is it a natural union? Is it a legal union? Is it a recommended one? Is it a union which is deadly required? Is it a fundamental in nature? Again, is it in consonance of society's health? Is it a westernized concept? Is it recognized union in ancient Indian culture? Is it a pure union which is expected to be a sacrament in nature? What will be the effect on the society of this kind of marriage if are recognized legally? Further, is it suitable to Indian culture? Is it going to get one more window open for committing heinous crimes like rape on men? Or if same-sex marriages are legalized, these kind of heinous acts like bestiality, adultery, rape will get reduced. There are different aspects attached to such kind of marriages. It is very clear that Bharat is known by its family culture. Ideal family culture exists only in Bharat. Now the countries outside realize this fact and have started adopting the family nature and culture throughout globe. You all are law students. You are supposed to think in legal manner and with legal insight. I hope with so many panelists today with us here, we will have a very fruitful, insightful and legal discussion which we all will enjoy. Government Law College, as you all know, is known for its legacy. Established in 1855, it is the oldest legal institute in Asia. Has given many judges, lawyers, freedom fighters, social activists, social workers, teachers to the society. We are very proactive in academics. We have conducted 161 different academic programs in the year 21-22, 136 in 22-23, 143 in 23-24, and we are conducting programs this year too. We have conducted 2 international conferences, 75 national events, and many more are in pipeline. I am very proud to communicate you, sir, that we have started 7 add-on courses for law students and LLM program as well as research center at GLC. Friends, we can do and conduct many activities because of the guidance of great luminaries like Honorable Justice Dharmadhikari sir, who always is a path shower to us. Sir, on behalf of Government Law College and from bottom of my heart, I welcome you, sir. Actually, we were expecting to have Shivanandan sir, former Director General of Police Maharashtra, to address the audience, but because of his some work he could not reach to us. I welcome all the panel members who have taken a lot of pains to be here and the students who are present here. I hope you all will enjoy this academic fest. I welcome you all again personally. Thank you very much.
Thank you, ma'am. Your insights are truly enlightening and inspiring.
It is an honor to request our Chief Justice to be with us. Justice S.C. Dharmadhikari, who has honored us with his presence. Justice S.C. Dharmadhikari, a retired judge of the Bombay High Court, has had a distinguished career in the field of justice spanning nearly 40 years. Beginning his journey as an advocate in year 1983, he was then elevated to the position of additional judge at the Bombay High Court in year 2003. Throughout his career, Justice Dharmadhikari was deeply involved in the legal aid movement, working to ensure access to justice for all. He contributed significantly to legal education at the Board of Studies of Law at the University of Mumbai and served on the disciplinary committee of the Bar Council of Maharashtra and Goa. Additionally, he played an active role in managing committee of the Bombay High Court Library. Beyond his legal contributions, Justice Dharmadhikari is committed to social causes, including his work with various institutions focused on the eradication of leprosy. I would like to extend a warm invitation to Justice S.C. Dharmadhikari to share a few words.
Madam Principal, Professor Daswani and the other professors, distinguished panelists, Mr. Ramachandran, Senior Advocate, Ms. Abha Singh and others. It's a pleasure to be here this morning. At the outset, I must apologize because I had told the organizers that after the opening remarks, I would be not available for participation in this event. There is some urgent work which I have to attend. Kindly excuse me therefore. And I am sure in my absence there are the panelists who will take care of all the questions and issues which are relevant today and for today's topic. Friends, we are, as reminded by the Honorable Principal, students of law. And as students of law, when we discuss such issues, we have to be aware of certain limits within which the discussion can take place. There is a role and earmarked for the activists in the field, the social activists, and others who want a mindset change, and the lawyers. All that is good for the society, all that is good in our minds and which we feel is necessary and relevant in today's world is not enforceable legally. Firstly, we must understand that there are matters which have been taken to court, including this issue. It was before the court and for a decade and so. The answers are given, but according to some, they are still not final. We must appreciate that a review petition is pending, and such is the nature of the discourse that I am sometimes surprised and shocked that even lawyers feel that there is a vacuum after Section 377 has been removed from IPC. There is a petition pending in the Delhi High Court, I am told, as to why Section 377 has been removed. It should be brought back. There are other petitions pending Is there something interesting, ma'am? You almost. There is another petition pending which says that the marital rape needs to be brought into, this concept needs to be brought into the now Bharatiya Nyaya Samhita. All this is therefore highly debatable, and within the limits of judicial power, the inbuilt and inherent limitations of judges, we must appreciate that there are no answers which we can get. Some things are justiciable, some things are clearly not. In today's world, and that is more concerning and worrying for me, remarks, comments, including from the bench, travel beyond the Indian territory. An impression is created amongst everybody that Indian judiciary is alive to all this. Indian judiciary is responding to all this. And even in regard to this matter, there was a heated debate on the street. When debates in the court were going on, when the issues were being sorted out before the court, parallelly on the streets, people were trying to give answers to the judiciary and to the public at large. They were trying to convince everyone as to how it is time and ripe for this recognition and status in law. They were not just satisfied with the judgment on section 377. They thought that the debate should go ahead, and there are certain rights which are created or which are vesting in this group, which need to be legally established and held to be enforceable, irrespective of the fact that there was no statutory regime. Some comments from the judges, which to my mind respectfully uncalled for, gave rise to unnecessary controversy. It was indeed avoidable. The judges ought to have been aware, and they were aware throughout, that there is a doctrine of separation of powers inbuilt in our constitution. The sphere is marked and reserved for Parliament, then for the judiciary, and then for the bureaucracy, or as we say, the executive. Parliament makes the law, executive enforces it, judiciary interprets it. But interprets it when there is a list, not when there is a creation of a list. Today, we must all be worried about the gross misuse and at times abuse of the jurisdiction of the courts. The superior courts are flooded and have no time for the traditional litigation because they have queue of PILs. Sometimes PILs are generated so that the judiciary goes and travels in a particular way or on a particular path, and we must all be aware of that position. First and foremost, therefore, students and tomorrow's academicians or practitioners of law, is that we must fully understand there are limitations, and we can't take every issue to the courts, find answers from the courts. Reforms and changes for the better are not necessarily brought through law and court. Of course, law could be the instrument of social change, and interpreters of law, aware of the social requirements and needs, interpret the law in that manner. But these are issues which cannot be carried beyond a limit. We have elected governments in power. We accept the fact that there is a majority and a minority or an opposition in the parliament. We also accept the fact that parliament debates, discusses, and thereafter makes a law. The presumption is that they know, as they are representatives of people, the requirements in the society. They represent the will of the people, as they say. Therefore, when the matter was going on the basis that not only there must be a freedom from the clutches of Section 377, but beyond that, you must give us status. You must give us and recognize certain rights vesting in us. The courts want, and sometimes to discuss this, or they encourage a debate and discussion. They want an active participation, so therefore they elicit responses and answers from the appearing lawyers. But beyond that, the matter does not travel. They were aware that if there is a special marriage act in the field, and that is a secular law, that employs and uses the words and expressions man and woman, for us to strike down that law would mean creating a chaos. If that law uses these expressions and words, we are nobody to substitute these or add to these words as man and man, woman and woman. Therefore, stopped short of saying that there is a right to marry. In fact, they said there is no fundamental right to marry. The impression given during the discussions and during the media discussions on the possible interpretations and on what views were expressed during the course of the proceedings gave an impression to the public at large, possibly, that they are going to do something which will result in a societal change, not necessarily for the better. Some thought that this is the conservative approach is the best. Some thought the progressive. Therefore, when the invitation was extended to me to be here, at the outset I told them that this is not something to be debated and discussed mainly in order to bring pressures on courts to decide in a particular manner. Matters are sub judice. We must resist the temptation to give our opinions and trying to influence the decisions of courts. That would be extremely unhealthy. The second discipline that we must follow is that we go by a statute law. We go by a written constitution. We go by what is expressly said therein. When there is a scope for interpretation, when there is scope for elasticity, when the words are not so plain, ambiguous and simple, or they are plain, ambiguous and simple, but resulting in chaos and absurdity, that there is a scope to apply principles of statutory interpretation. Else, we must go by the letter of the law. When we have the personal laws, when we have a vast field of other legislations peculiar to societies, peculiar to communities, peculiar to even tribes in our society, then it is very, very questionable as to how the issue like this, which is complicated and complex, can be resolved even by the parliament. The Uniform Civil Code was a discussion, I was told, held under the auspices of this society. We may generate some opinion on that, but everybody amongst us knows how difficult it is for administrators and lawmakers to frame an ideal code. The majority and majority's personal laws cannot be forced upon everybody who is not in majority, who have a distinct identity of their own. They safeguard and protect it and have been doing so for decades together, post-independence for 7 decades and more. So Uniform Civil Code may be legislated upon, but ultimately when the subject is of entry 5 in the concurrent list, and when there are parliamentary statutes in the field, every single parliamentary statute to be repealed would require generations to come. We must have patience. I hold no opinion either way on the wisdom and feasibility of introducing something like this in our statutes, giving rights. But ultimately, even the Supreme Court had to stop short of saying that there should be a respect for minority within the scheme of our constitution. Minorities in different ways, thinking minorities, minorities who want a particular orientation, all of that has to be respected. There is a certain place for all of them. Beyond that, the subject was not to be brought before the Supreme Court. It resulted in a minority view. The majority view, and mind you, was also inclusive of that of a woman judge on the bench. It is somehow that we are thinking that to be progressive, we must be advocating this. For a union to become a marriage, for every relationship to be a marriage, we don't know that there is a statutory regime which must follow that. You can't say everywhere there is a bond. Just as we say marriage is beyond ceremony, wedding may be a ceremony. Marriage is a continuing bond relationship, foundation for something, equally succession, equally adoption. All of these are, you see, a compendium or a bundle of rights which flow from personal laws and to individuals. Some may have them, some may have all, some may have none, some may have only some of them. This is what we call a diversity. And when there is a diversity, there can be unity. India has been an example of that. Trying to topple everything, giving a handle to somebody who wants to enforce and impose on the people a majoritarian view is not ideal. Let us not encourage an imbalance in the society. When there are certain disciplines, I would urge everybody to hold such a debate within the four corners of all this, and particularly noting that we are before students of law. Students of law are not to be confused. They should not be told to follow a particular view. They should be free to debate. There is a freedom to debate, to discuss, to deliberate, inbuilt in the right to free speech and expression. Therefore, dissenting views are always welcome. It is better to discuss things threadbare frequently rather than trying to influence certain positions, particularly relating to matters which are pending in court. Before concluding, I would say that we are readers of law. A statute must be read as a whole. Every single word and expression is not inserted therein without any reason. As Justice Chinnappa Reddy would caution us all the while, that there are certain presumptions and we must follow and respect them for times to come. He used to say that the Parliament sits to make a law because it is necessary to make a law. Parliament does not make a law or amendment in the law because it feels that it is not necessary. Parliament does not do anything just to while away time, just to pass time. Similarly, Parliament doesn't insert words and expressions without having anything with regard to its meaning in mind. When it is struggling for words, it doesn't open a dictionary and take a word or pick up something and inserts it in a law. All and everything has a place. Everything must be read together and harmoniously. If you read like this, you will realize the futility of certain debates. And that is how, because 377 is removed, oh, what is going to happen? Anything against the order of nature, carnal intercourse will no longer be an offense. Unimaginable. For me, it is unimaginable. See the BNS, read it fully. You will find that there were several provisions and inserted particularly after the Nirbhaya incident in the criminal law amendment of 2013, which required that there should not be a separate section like this. As far as section 375, its rewording, its amendments. Similarly, within insertion of POCSO, with similar stringent provisions to be found in IPC already, there was no need. But that does not mean that this is not an offense. It would be an offense, it would be in another form. You can't inflict cruelty on somebody. Any relationship, that is what you will find in BNS. All of this is present very much. Then why have a debate on what will happen if 377 is not there? It is very much present. It will be only a little time that will be required when the laws are read in the manner which the Supreme Court wants us to read, and repeatedly. Thereafter, you will find answers. Similarly, if you are going to insist on bringing back 377 and going to court, we must first ask the question ourselves, what is our right? Is it a fundamental right? Is it a constitutional right? Platforms of debate are different. Platforms of discussions are different. And merely because some issue is hot according to us, it cannot be taken to court. That should be justiciable as well. There should be something within the judicial control, and that only you can get answers. But several of these matters are taken to court, and I would not express any opinion when they are sub judice. I would wait for the answers to be given. Similarly, I would expect all of you to raise questions and try to find answers, but within the four corners and limits outlined by me. I thank the organizers for inviting me, and I now open the debate for all of you, but kindly excuse me. Thank you.
Thank you, sir, for your remarkable insights. It's truly an incredible opportunity for our students to learn from you. Now, to bring our opening ceremony to an end, we would like to proceed with the felicitation. I kindly request our principal, Dr. Asmita Vaidya ma'am, to present a token of appreciation to our Chief Guest, Justice S.C. Dharmadhikari. Thank you, sir, for gracing us. Now, I would like to invite our professor in charge, Professor Shweta Shiraskar, ma'am, to present a token of appreciation to our principal, Dr. Asmita Vaidya, ma'am.
Thank you, ma'am, for joining us. I would now like to invite the Debating and Literary Society's convener, Riya Narkar, to join us on stage and present a token of appreciation to our professor in charge, Assistant Professor Dr. Anita Desale, ma'am. Thank you, ma'am, for support and guidance. I would now like to invite the Debating and Literary Society's convener, Aryan Gaurav, to join us on stage and present a token of appreciation to our professor in charge, Assistant Professor Dr. Shweta Shiraskar, ma'am. Thank you, ma'am, for all the support and guidance.
I request the Chief Guest, the Principal, and the Professor in charges to take their designated seats among the audience now. Government Law College, founded in 1855, is the oldest law college in Asia and enjoys a preeminent national and international reputation for excellence. Its rich and widely spread alumni includes legal luminaries par excellence, such as Dr. B.R. Ambedkar, Nani Palkhiwala, Lokmanya Tilak, and Justice M.C. Chagla, just to name a few. Most of the top-notch counsels and legal practitioners who virtually built and ruled the entire paradigm of the India's national profession and legal profession and have also passed down the portals of this great institution. The college derives its strength and ethos from the spirit of free discussion and debate, and in this light that the Debating and Literary Society was established. Since its inception, the Debating and Literary Society of the Government Law College has promoted discussion, discourse, and dissent as a medium to engage and widen one's horizons. The policy debate is one of our flagship events where we seek to discuss important issues that affect the society as a whole. In previous iterations of the policy debate, some of the most learned and eminent dignitaries discussed a range of topics, including India's place in the international community, the collegium system of the judiciary, and the Uniform Civil Code. Each year, with the desire to improve and better ourselves, we strive hard to bring you a scintillating panel discussion that will enrich your mind.
So once again, ladies and gentlemen, the Debating and Literary Society of Government Law College proudly presents to you the 9th edition of the policy debate. This time, our panel engages on the topic, marriage equality, a relook on same-sex unions. Same-sex relationships have been a taboo topic in society for as long as one can remember. However, a demand for recognition from members of the LGBT plus community has always persisted. With the decriminalization of homosexuality and the application of Section 377, the topic of the rights of the members of the LGBT plus community have become a matter of conversation in not just social contexts but also legal spheres. The question of conjugal rights becomes an important one in this context for the realization of equal rights to all citizens. When looked at with a closer lens, further questions arise. Whether the power to realize equal conjugal rights rests with the judiciary, or can it be addressed through legislation only? Are conjugal rights even fundamental? We are here to delve deeper into these and more such questions regarding marriage equality and the status of same-sex unions in India today. Without further ado, we present to you our esteemed panelists for today. Dr. Aqsa Shaikh, one of India's first transgender doctors, is a professor of community medicine at Jamia Hamdard, New Delhi, and a prominent advocate for transgender rights and healthcare access. As part of the I Hear initiative at Sangat India, she promotes inclusion for transgender and disabled communities. Founder of the Human Solidarity Foundation, she is also a TEDx speaker, poet, and theatre practitioner advocating for trans rights in India and globally. Thank you, ma'am, for gracing our event. I request you to kindly join us on stage.
Senior advocate Raju Ramachandran studied economics at St. Stephen's College and law at the University of Delhi. He enrolled at bar in year 1976 and became a senior advocate in year 1996. He served as Additional Solicitor General from year 2022 to 2024. He was also appointed amicus curiae in significant cases like the Gujarat riots case and Ajmal Kasab case. He recently also represented the petitioners in the same-sex marriage case in India. Thank you, sir, for gracing our event. I request you to please join us on the stage.
Ms. Chayanika Shah is a Mumbai-based teacher, educator, and gender studies researcher. She teaches physics and has extensively campaigned and written on feminist studies of science, population control politics, reproductive technologies, communalism, and sexual rights. A member of Hazrat-e Zindagi Mamuli, a queer trans feminist organization, she was a petitioner in the marriage equality case. Her notable books include Space, Segregation, Discrimination, No Outlaws in the Gender Galaxy, and We and Our Fertility. Thank you so much, ma'am, for gracing our event. I request you to kindly join us on stage.
Advocate Suraj Sanap is a research consultant with the Center for Health Equity, Law and Policy, C-Health, specializing in legal policy around health, gender, and sexuality. He led the legal team in the year 2023 Supreme Court case advocating for marriage equality under the Special Marriage Act. With prior experience at Lawyers Collective, Suraj sir contributed to landmark cases like the decriminalization of adultery and sodomy and the right to privacy. He has collaborated with queer, trans, and PL/HIV communities and worked on international law reforms. He holds an LLB from our very own Government Law College, Mumbai. Thank you, sir. Kindly join us on the stage.
Advocate Abha Singh, a practicing lawyer at the Bombay High Court, is renowned for her work in women's rights, gender equality, and justice. She holds an MPhil in child rights from Jawaharlal Nehru University and gained national recognition as the third runner-up in the 2008 Times of India Lead India campaign. Her leadership and dedication to social causes earned her a TEDx Oxbridge speaking invite in 2017. Ma'am continues to be a prominent advocate for social change and women's empowerment in India. Thank you, ma'am, for gracing our event. I request you to kindly join us on the stage. All that we've just said about our panelists in their introductions is just a fraction of all that they've achieved. They're all prolific in their fields and have created an everlasting impression with their contributions.
And lastly, I would like to call upon our moderator, Professor Kishu Daswani, to join us on stage. Professor Kishu Daswani has been a professor of law at the Government Law College, Mumbai for 30 years. He has also been a professor of international and humanitarian law at the Rotary Peace and Conflict Resolution Center at Chulalongkorn University of Bangkok, Thailand. He has conducted over 50 workshops in peace and conflict resolutions in colleges with Indian and international students. He is also a visiting professor at the Naval War College, Goa. I would now like to invite Professor Daswani to kindly offer his opening remarks.
Good afternoon. It's just 5 past noon. Honorable Justice Dharmadhikari, Madam Principal Dr. Asmita Vaidya, my fellow faculty, the panelists, students, friends, law students, non-law students, all are welcome here to the 9th policy debate. Now, I'm supposed to set the tone for this debate in this hallowed academic hall, whereas Justice pointed out to us that we should have the freedom of speech within the parameters of the law and within what is permitted. So let me start with the animal kingdom. Birds fly, fishes swim, animals walk on land. But is there something common between all of them? They reproduce. They procreate. And it's not that they go to school and they get sex education. They do it as a matter of instinct. So one of the key things about survival of the species is procreation. Having said that that is in the animal world, in our human society, procreation is through the institution of marriage. Whether it be tribes in Africa, whether it be people in South America, in Europe, Asia, wherever, the institution of marriage has always seen one of the fundamental requirements being procreation. And we do realize that for procreation, you need a man and a woman. Let's go a step further and look at what some of the major religions of the world say. In Hinduism, marriage has got 3 functions. One is dharma, that is to perform your religious duty. You have the man and the woman going around the fire doing a yajna, and your marriage is a religious duty for you to do dharma. The second function in Hinduism is praja, that is to have progeny, to have children. Of course, the traditional mindset was in Hinduism, you need to have one male child to do your pitradini. Otherwise, to have progeny and grow as a family is your second function. The third function in Hinduism is kama, that is to have sex, which is looked down upon to some way over dharma, but that is also one of the requirements of Hindu marriage. Migrating to Christianity, the fundamentals of marriage in Christianity are, number 1, companionship. To live with the person you love and be faithful to that person. The second aspect of Christianity and marriage is procreation. To have children who will follow the way of Christ and will live in a God-fearing home. The third element of marriage in Christianity is redemption. And I'll quote to you, is to release the men and women from their sins by getting together in holy matrimony. As such is the union between God and the church. In Islam, the functionality of marriage is that 2 sexes get together, they have companionship, and they bear children. Now, this debate is starting on the background of thousands of years of religion, community, and society. But if I was to flip around and ask this generation, and please do not accuse me of being a schizophrenic, I'm just setting the tone for the debate. If I was to turn around and say, what does marriage really mean? Is marriage really an authority for you to have exclusive sexual relationships with somebody else? When I say exclusion, to the exclusion of society. Is marriage about love? Is marriage about finding your partner? Is marriage about companionship? Is marriage about having somebody with you who is going to evidence your life, who is going to be with you through your joys and your sorrows, who's going to acknowledge your accolades and criticize your downfalls? And if that is what is marriage today, then nowhere does it say that a marriage has to be between 2 persons of different gender or sex. If the functionality of marriage, if marriage has morphed over the years and marriage has become something else, today we hear words like dinks, double income, no kids. People marry not with the intention to procreate. They marry with the intention to have companionship. They marry with the intention to have a family, and family does not necessarily mean your natural kids. A family would mean two people who are able to function as a family, because a family is the critical building block of society. You want to go somewhere, you want to go with a companion, you may want to go with a partner. If that is marriage, and not what I said earlier about the religious connotation of marriage, this opens the debate to a different need that the society may have. The answers, as Principal Ma'am said, are not simple. And as most things in life, the answers might be somewhere in between the black and the white. Now, having said this, and what Justice very, very well put out, that the court has already laid down its limitations within its parameters. The Supreme Court has already spoken and has given its verdict. It has put the onus on the legislation to form the laws if the legislation wants to. Effectively, the debate has now moved away from the Supreme Court, subject of course to the review petition, and from the Supreme Court it has gone to the Citizens Court, and that is all of you here. So within the parameters of the law, as the Honorable Judge put, we shall have this debate, though I want to tell my panelists, you are in Government Law College, the College of Ambedkar and Tilak. So feel free to voice your opinions, feel free to say what you want, because we are in an academic zone where there are very bright young minds there who will definitely take their own opinion home regardless of which way you try to steer them. No, sir.
This is a Sarkari institution.
No, sir, not at all, sir. In fact, I would want to tell you that, we are a government law college. So we are, thanks to Madam Principal, we are very, very well endowed with a robust student body that is able to actually speak their opinions. I mean, is this not an indication of the robustness of this college? Round of applause. In fact, I just want to share with you, and I have had the good fortune and privilege for being the moderator for the last 9 editions of this debate. We've had debates on cracks, no, this is not me. We have had cracks in the pillars of democracy. We've had debates on the collegium system. We have debates on the Uniform Civil Code. So ma'am, thank you very much for creating a robust platform for discussion. Right, I forgot to tell you something. Please listen to this panel why they say panel? Listen to these debaters very carefully. You can ask questions at the end of it. As usual, there's a prize for the best question. Yeah, it's a return ticket to London. Yeah. Yes, So please ask your questions later on. I'll ask Mr. Raju to please give his opening remarks. All the speakers will give their opening remarks, and then we'll go to a round of questions, and then we throw it open to the audience. So.
This is better, more informal. Thank you, Professor. Before my opening remarks, can I make some pre-opening remarks? First, it's a matter of great honor and privilege for me to be in this august institution, this iconic institution which has produced such legends of the bar and the bench. So many of my own personal icons have studied here and taught here, and so I am really grateful for having been invited here. Second, before we get into the meat of the present debate, I also wanted to share with you, which is in response to what Justice Dharmadhikari said, that since we are in an academic forum and a student body, sub judice also has its limitations, and sub judice also has its place in matters of important matters of constitutional import, where the nation is interested, the population is interested. The whole idea of live streaming proceedings is that the public should be engaged. And therefore, the old doctrine of sub judice, especially in today's context where a case has been decided and only a mere review petition is waiting to be decided, that should not inhibit our debate. And in a student body like this, please don't lose your irreverence. You can be respectfully irreverent, and that's what I hope to be, and I hope all of us will be. Now, as the opening speaker on this case, I can offer only a legal perspective, a lawyer's perspective. I don't come from a background of activism. I don't have field experience. It is just that I've had the good fortune in my career to be associated with cases like this, and I think I was chosen to argue this case only because I had argued the earlier Nalsa case about transgenders. So I am not an activist lawyer, and the points which I am making would be legal and not emotional, or at least I hope I am not being emotional. Now, the prayer of the petitioners, which started with a declaration of a fundamental right to marry and unconstitutionality of the Special Marriage Act, is not as far-fetched as it is made to look in some quarters. And let me explain to you why. After Navtej Singh Johar, after 377 as it stood went, the prayer in this petition was only a logical consequence. It had to follow. If there was a right to choose whom you love, whom you cohabit with, then it had to be logically carried forward, and that is what we tried to do. In fact, of course, it was a view of one judge, Justice Chandrachud, as he then was in the so-called love jihad case, Shafin Jahan, that there is a fundamental right to marry. Of course, it's the observation of one judge. But the point is that if there is a right to equality, that right to equality should extend to the benefit of all social institutions. Because the Supreme Court, in its majority view in this judgment, and I am assuming that all of you are familiar with this judgment, appears to say that no, marriage is not a creation of the legislature as such, it's a social institution. Yes, it's precisely because it's a social institution that people who don't love in the conventional way are entitled to the benefits of all that society has to offer. And just analyze it a little more closely. Right to love and the right to marry, right to love has already been traced to Article 21. We tried to put the right to marry also under 21. That being part of personal liberty. And once ADM Jabalpur was overruled in Puttaswamy, it meant that it inheres in an individual. There was one shocking statement in ADM Jabalpur by Chief Justice Ray, as he then was. Liberty is the gift of the law. Please note, one judge, a Chief Justice of India, said liberty is the gift of the law. It is that position which was decisively overruled, earlier dissented from by Justice H.R. Khanna in his famous dissent, that liberty inheres in man as a human. So, if liberty inheres in us, then the right to marry is an inherent part of our dignity, our right to life. And when we were asking for interpretation of the Special Marriage Act, we were asking for reading down and reading in. Now, the same Special Marriage Act, Section 4 says 2 persons. It starts with 2 persons. Then man and woman come in only when it talks of ages, 21 and 18. So it is not so far-fetched to say, read 2 persons throughout. And for years, courts have been reading may as shall as may. So what was so far-fetched in asking the court to perform this interpretative exercise? All right, the court didn't want to go far enough. But the biggest disappointment was that even the right to form a civil union was not found fit to be granted by the majority. For me as a counsel, and now I'm sharing my experience as a counsel in that case, that was very disappointing. You don't give a right to marry, you say there's no fundamental right to marry, but you don't even give the right to form civil unions. Then what was the use of Navtej Singh Johar? And the other disappointment, two more disappointments with this. We challenged and we argued at length the question of the constitutionality of the provisions of the Special Marriage Act, which provided for giving of notice. This notice provision had been challenged in other petitions also pertaining to heterosexual marriages, but it was squarely raised here also and argued here. But then the court decided not to decide this, saying the question is pending elsewhere. But it was arising here. It was arising here. I hope it is not my voice which shook the mic.
Your voice shaking a lot of things.
So the fact that notice had a chilling effect on the exercise of choice. Now forget marriage for a moment. Even when two people decide to live together, the fact that same-sex couples faced danger from their own families, that they had to be in hiding from their own families, is something which ought to have aroused the concern of the court, as it did at some point of the hearing. But it was disappointing that even our prayer, limited prayer or the last prayer, that the court should lay down a protocol of protection for same-sex couples. Forget about marriage. Even that relief was not granted by the majority, and ultimately it was left to a committee to be headed by the cabinet secretary. That was the biggest letdown of the judgment. I'll stop because these are only opening remarks and hand it over to the moderator to give it to the next panelist.
Thank you. Thank you very much. Thank you very much, Mr. Raju. You, I think, gave all of us a very broad indication of why the court maybe said the right things but did nothing. See, the court, and in fact, what also you must realize that this was one of the rare occasions when the Chief Justice was in the minority. Normally, the CJ is in the majority. I think this is the third instance that this is, third or fourth instance this has happened. Now, also, thank you very much for drawing out the distinction for the Special Marriage Act, that the words man and woman in the Special Marriage Act are mentioned only so that the ages are different. And if probably there was no qualification for the age difference, then the Special Marriage Act could be read universally. That's a very good observation. And also the observation on fundamental right, because if your right to live, and right to have a wholesome life, and marriage being one of the premier requirements of being acceptable in society is there, that even if I was to decriminalize, homosexuality, the fact is I'm not giving a same-sex couple the whole right that is available to other people who are not the same sex. Thank you very much for that. Can I request Ms. Abha to take on from here?
A very good afternoon. After such an illustrious speaker, that too from Supreme Court, where does an activist lawyer stand? But the biggest issue I feel, marriage equality, I would have first wanted to say that in actual marriage that it exists today is there equality. So, but we have gone one step ahead because the parameters are same-sex unions. So, number one, I wonder why did Supreme Court even get into it, because when it was trying to say that we are only going to talk about civil union, when in Navtej Singh Johar case 377 was decriminalized, I think that was a big victory because it made the transgender, it made the people who were suffering, all the communities that had gone to the court, that it was a big victory, that now the police cannot trouble you, false cases cannot be filed against you, and the punishment was so high. So that was a big victory. And then someone said that next step was marriage equality. But I would say we should have stopped there and rejoiced that first, because that itself was a marvelous thing. And let me tell you, not only for the transgender community, but even for normal marriages, striking down of 377 is a landmark, because I, as a family court lawyer, I have seen so many husbands suffering because the wives have slapped 377 on them only to knock off money. And these husbands who are parents of 2 children have come and wept and said, how do we even go to the house and face our children that this is what we've been doing? So not only in the larger interest, striking down 377 was a landmark judgment, but yes, marriage is not a fundamental right. Otherwise, all parents like us would be running helter-skelter because our children would have bullied us left and right. So that itself, that marriage is not a fundamental right. It cannot be imposed by the court. At a time when we don't even have a uniform civil code, we cannot bring all these parameters like marriage, adoption, divorce on a common platform. How can we even go ahead and talk of same-sex marriage? We are going ahead. We are running through things. Let us go step by step. If you want some change in your traditions, culture, you have to go to the public. And that is what the Supreme Court said. Supreme Court is there to see the constitutionality of a law that is passed. A law which has not been passed, how can Supreme Court talk about it? It is for the Parliament to decide. It is for the Parliament to make a law. And when there is a problem in the law, then Supreme Court comes in. So I think we were a little early going to the Supreme Court, and the Supreme Court setting up a 5-member bench was not the right time it should have come. Thank you.
Well, thank you, Ms. Abha, for telling us exactly why marriage is not a fundamental right. Yes, because I really cannot see the state providing for every individual in this country a spouse. See, say, look, it's a fundamental right. The state must guarantee me, abhi shadi kara lo. See, so that would. Yes. So you know that brings a very different dimension. You see, and that's I think what this debate is all about. Is bringing a different dimension. From one aspect, we are viewing it, marriage is a fundamental right, because if privacy can be a fundamental right, okay, and your decision of who to marry and who to you live with is a private decision, so marriage should be a fundamental right. But you can hear a completely contrarian opinion here on what are the dangers of going down that road. Well, now I will ask Ms. Aqsa to please address this, because, you know, there was a question raised here by Abha, so maybe you can address that.
Hello. Thank you for this opportunity, and a very good afternoon to all the ladies and gentlemen and all those who do not fit into this binary. And a very good afternoon also to all the equals and the unequals who are sitting in this room. You know, the first article of the United Nations Universal Declaration of Human Rights says that all human beings are born free and equal in dignity and rights. But unfortunately, some of us have to knock the doors of the courts to secure those rights. And one such group is the transgender community. I am going to restrict most of my comments to the trans and the gender diverse community, because that's my identity. I am a transgender woman myself. And therefore, I wouldn't want to speak for the entire community or to speak for the entire queer community, and try and restrict my arguments mostly for the trans community. We, of course, have representation from other queer communities here. Trans people, of course, as you know, are people whose gender identity is different from what is assigned to them at birth through their sex, with the conflation of sex and gender, by their families, by medical professionals, or by the society in general. And it's important to understand that it's not a choice. It's not an identity that transgender people have chosen for themselves. It's the affirmation of that identity or expression of that gender which is a choice, and not the identity per se. And therefore, to deny someone rights on the basis of something which they did not decide to do is faulty in the principle. Now, the transgender people, of course, have been a part of our society, our mythology, our culture, and even media for a very long period of time. But unfortunately, they have been invisibilized when it comes to rights, rather even criminalized through some of our earlier British acts. It was only in 2014, of course, as you all know, when the Supreme Court in the Nalsa versus the Union of India judgment, in which we have our counsel sitting here, took the cognizance of this injustice being meted out to a very marginalized community and recognized them as an equal citizen, conferring the label of the third gender and giving them the dignity, freedom, and the rights that they have been deserving all along. Subsequently, the Indian Parliament, just within 5 years, which I would say is not a very long period of time, enacted the Transgender Persons Protection of Rights Act 2019 and Rules of 2020. The Trans Persons Act, and I'm sure most of you must have read that, and it has a lot of room for improvement. We cannot say that the wisdom of the Parliament is absolute and every grammar and word that they use is perfect. Remains silent on the conjugal rights of the transgender persons. And this is where the judiciary filled in the vacuum and gave some relief through court judgments like in the Arun Kumar Shrija versus the Inspector General of Registration, and in the recent Supreo versus Union of India, where it talked about the rights of the transgender persons to marry, but strictly within the heterosexual and the binary confines. This, of course, is antithetical to the entire existence of transgender and intersex people who are, by their own personality, are breaking the binaries of genders by saying, we are neither a man nor a woman, we are a third gender. Many of them say that. and intersex people who say we are neither male nor female, but a part of another sex variation. Now, to say that the allowance of the marriage only within the binaries of the two genders, that's men and women, or the two sexes, that is a male or a female, tries to put trans and intersex people into the very boxes that they've been trying to escape out of. And also this limited provision of marriages for trans men and women with each other, means trans man with a trans woman and vice versa, further limits the rights which are ancillary to marriage, like adoption, surrogacy, assisted reproductive techniques, or inheritance, which are not fully available to trans people, and most of the times they have to go to the courts to secure those rights in the specific cases. And we all know that they'll only be available when the original laws, are going to be amended, and of course that's going to take a lot of time. Also, we need to introspect on the significance of marriage itself in the contemporary and evolving Indian society, as Professor Daswani mentioned in their opening remarks, and question if, rights to have a child through techniques which are medically available, like surrogacy or assisted reproductive technique, should be dependent on a marriage certificate. Because currently that's what the law says, that it's only available to heterosexual married couples or to single women who are divorced or widowed. Now, while we demand the equality of right to marriage for queer people, we also need to think in the long term if we are really giving a lot more power to the institution of marriage, when the larger goal is to really break free from the shackles of an institution whose time has probably run out, and which confines the emotions of love, relationship, kinship, or conjugal rights. Also, while marriage may be the building block for family, as has been repeatedly talked about in the cisgender heterosexual normative society of ours, the same is not true for the transgender persons and the various ethnic groups like the Hijra, Kinnar, Aravani, Jogta, Jogappa communities. The Hijra Kinnar Gharana system, for example, with its Guru Chela system, that has been a very time-tested structure of family building inheritance, gives an alternative imagination for making families without marriage. And these are people often who are forsaken by their own families and the parents who had a heterosexual marriage and were supposed to be taking care of their children irrespective of who they are. The gharanas, which are matriarchal in a society which is predominantly patriarchal, have shown how marriage is not always necessary or even desired to create families. Now, in such a system, it's important to understand, and this has been repeatedly told by the Justice Dharmadhikari, by everyone else on the panel, that the wheels of justice move slowly, that the societal change and changes for law in the parliament are going to take time. And it will take a lot of efforts, advocacy, and social change for that to happen, for all the queer people to really become equal citizens in the society. And as Advocate Abha mentioned, that are really women also enjoying the equality. And we know that for women to enjoy an equal status in our society, it will probably take 100 more years. So how many more years really it will take for trans, intersex, or queer people to truly become equal in our society? The question is, will it happen in my lifetime and your lifetime? Justice Dharmadhikari started his practice in the year in which I was born, 1983. They've already retired. The question is, will I get justice before I retire at the age of 70 years? And will we be even alive, when justice, liberty, equality, fraternity, all which is mentioned in the preamble to our constitution is secured for us? I hope we'll be alive and see that change happening. Thank you.
Thank you. Thank you very much, Aqsa. Very, very different perspective. Thank you very much for that. I really got some great takeaways from what you said. And, starting from what you said last, the wheels of justice move slowly. But why are we waiting for the wheels of justice? What about the wheels of parliament? The parliament can pass laws very fast. We have seen that. It can happen. So probably we are... No, did I say something wrong? No? Okay. So, here is the court of the people. if the parliament can move fast when it wants to move fast, so probably we are looking at, as has been said, the wrong forum to get the relief that we want. Also, you made one very interesting statement, which I'm going to ask you to come back to later. You said an institution whose time has run out. Yeah, I would like you to, probably explain that when you come back a bit later. Also, what Aqsa just said, just think about it. You're trying to fix a round peg in a square hole. It's not going to happen, because you do realize that transgenders have been a part of Hindu culture in India for years. They've always been accepted. They've been a part of society for years. It is only the legislation that has marginalized the transgenders. So it is important that the legislation that is marginalized has to do justice to bring them back into the ordinary fold and give them the benefits as would be required within the framework. Now I'm going to ask Chayanika to please give your opening remarks. Yes.
Thank you, and good afternoon to everyone. It's been very enlightening listening to people up till now. I'm not a lawyer, and I just had some pre-remarks like Advocate Raju Ramachandran had. I come from an equally objective discipline of science. Equally objective, as in law is supposed to be objective. And I have been looking at science very critically for the last many years. I don't think there is absolute objectivity in anything. The fact that the 5 judges differed in their opinions means that interpretations of law are different for different people. And so, as we talk here, I also want to underline that the petitioners who went to court were also very different. They also came from different locations, and they were making different demands. And somewhere those nuances get lost in our speaking of this as a single-dimensional case. So I'll just introduce some of them. Aqsa introduced some of the complexities of what marriage equality was all about. It was not about equality within the relationship. It was about equality in the eyes of law for everybody. We don't ever refer to it as same-sex marriage, because then that is restrictive, just like Aqsa just explained. In 2014, the Supreme Court did something which, if I heard the earlier remarks today, I would think is totally outside. It's absolute overreach, the case in which you argued. It actually said that there are more than two genders that live in the world. It also said that gender is self-determined. It's not determined by the body. I find that a very, very liberating idea for all of us. And I think that it's not about the rights of trans people alone. It's about for all of us to rethink what is gender, to rethink what is sex. And 2018, when it read down 377, what did the court do? The court opened the understanding of sexuality for all of us. It was not only for people who had apparently behaviors that were unnatural. Anal sex, oral sex, sex that is non-penovaginal is not only done by people in so-called same-gender, same-sex relationships. What we were living under till 2018 was the fact that nobody could have penetrative sex other than penovaginal. We were all criminals under the law. Because some of us were protected by institutions of marriage, that we were not caught. Some of us were protected by acceptance of heterosexuality, that we were not caught. So I think the Supreme Court from 2014, 2018, the Delhi High Court before that in 2009, and multiple examples from the Supreme Court of stretching the limits of societal understandings within the framework of the Constitution. That is what people went to court with an imagination that this could be done again. It did not happen is a different matter. And we as a person who's lived very long, I can say that when we filed the first time in the Delhi High Court, we were sure it was not going to happen in our lifetime. I'm here. It happened just when I took voluntary retirement at age 50, right? So it happens. And when in 2013, it was taken back, we all said we are not going back. No going back was the slogan with which all of us hit the streets. I must tell you that disciplines like science, and I separate medicine from there, science, law, and medicine, all of them respond to public opinion. And public opinion is very important because that is what actually decides things in each of these disciplines. Especially in law, we have umpteen examples. In medicine, we have umpteen examples, but we also have umpteen examples in science. So, with that in mind, I would like to say, as I was a petitioner, along with 3 others, so there were 10 of us who were petitioners. There are 4 of us who are activists, who are part of the international network of LBI women, lesbian, bisexual, intersex women, and transgender persons. And there were 3 couples who were anonymized. And all of us went to court with this petition very late in life because we felt that the earlier petitions were not really arguing what we wanted to argue. I must underline that the 4 of us who were individual petitioners, who were activists, I think all of us have gone on record to say, I don't want to get married. Because I agree with Aqsa, marriage is an outdated institution. But the 3 anonymized couples, and they were anonymized, and I feel that's important. They were anonymized because they were in danger. Similarly, I think the case that you argued, the couple was anonymized. They were in hiding. They were running away from natal family violence. Much has been said today about how marriage is important, or the core crux of marriage is reproduction. I think it's a step backwards. Core crux of marriage is reproduction. What does marriage reproduce? Marriage reproduces religion, caste, community boundaries. Marriage reproduces control of family over its members. And what successive judgments from the courts and actions by activists, feminists for a very long time, had tried to do for many years to open out the institution of family and marriage, I think this was a regressive step in that sense. Of course, as an optimist, I will always interpret it the other way. And that's why I think the Supreme Court is saying, and this I remember, there was a lawyer friend sitting with me in the court, kept listening to people speaking. And she said, my daughter, who's an adult, 30-year-old, in her 30s, is living with a man, doesn't want to get married, and everybody is asking her, why you're not getting married? And here is the court and everybody here who is telling all the queer and trans individuals, don't worry, don't get married, but you can live with each other. So I think the message to all of you who are straight is that don't worry, you can live with each other. The court will look after you. The state will look after you. It will protect your rights. You don't need to marry. So if there is no fundamental right to marriage, there is no fundamental obligation to marry also. Remember that, and I think for young people it's very important. The second point I want to make, the next point I want to make is that why we went to court, one of the reasons, yes, if rights accrue only from marriage, everybody deserves those rights. And it is a right to equality. But we also went to court seeking protection. Please remember, Special Marriage Act came in to allow intercaste, intercommunity marriages. It was something that broke religious law. It said you can stay within your own religion and still be married to somebody else, which no other personal law allowed. So it was something, it is something. And that's why the notice period is being challenged because of that. It is something in today's times when the world wants to speak of love jihad and wants to make this even more stringent. Not allowing people to marry across religious boundaries is something that the present environment is wanting. Special Marriage Act has to be protected. Special Marriage Act has to be reinterpreted. That is what we were saying. If the state stepped in to protect its citizens' rights to marry across religion and to continue to remain in their own religious whatever beliefs, then the Special Marriage Act also could be extended across genders. And that's why we went to court. So protection from natal family violence was one of the major reasons why we went to court. Marriage gives that protection along with the bouquet of rights. We all speak of the bouquet of rights, but we don't speak of the protection that marriage gives. That protection is what we went to seek. We are highly disappointed that the court did not think it important that its individuals are dying. Its individuals are facing tremendous violence, and there is a report that was produced by People's Union for Civil Liberties and the National Network for LBI Women and Trans People, which came out just as the court hearings were going on, which spoke of violence by the natal family, where individuals came and spoke to the panel. And that tells us this is not a one-off incident, right? So that was the second. And the last thing which we went for is that we don't want only conjugal families. We want families that are different. We want to make our families in the ways that we want. We don't want to be restricted by coupledom. We don't want to be restricted by conjugality. And so we had, and why do we need that? Because if I don't do that, as a single person also, whoever I am, de facto decisions in a situation where I cannot take decisions, de facto my family takes decisions for me. And my family does not know everything about me. There are other people who do. There are other people who know what I want. And I would want to appoint them as people who will take decisions for me. And that was a demand which was not even discussed in court. It said that protection from natal family violence for couples, which could have gone into the civil union at least, or a protocol for protection, but it also said that as individuals we are also under attack. And how do I protect my right to be who I am? I asked that let family not be the automatic choice. Give single people also a choice to decide, single meaning unmarried. Give unmarried people also a choice to define family. And that is something that they did not even consider. So that's where we are. Thank you.
Thank you, Chayanika, very much. First of all, I thank you for rubbishing the fact that reproduction is necessary for marriage. I had to put that on the table, but that was a great analysis of what the petitioners went for and how the nuances were lost. Also, you were happy with the Nas Foundation judgment, the Delhi High Court. I just want to tell you, AP Shah is an alumnus of this college and closely connected to Government Law College, the person who passed the Nas Foundation judgment. Yes. It's very important what Chayanika has just said, and she says she's coming from an activist background. I don't believe that. She was right on the legal button. The fact that she said that multiple petitioners can actually destroy the relief that you're seeking for, because each one is asking for something different, and the real relief gets lost. Different causes of action are there. The interest may be the same, but the real relief. So that's, I think, a great learning for law students here to see when they are ultimately going for petitions. Well, Suraj, you had a longish wait, so go for it.
is audible. Okay. So I was appearing in the superior matter in the Rituparna Bora petition, which included Chayanika and 3 other LBT petitioners and 3 couples, as she mentioned. What I'll do is just share opening remarks on some of the issues that we try to discuss in the Rituparna Bora case, as well as my opinion and response to some of the findings by the court. Firstly, on some preliminary remarks on the issue of the institution of marriage. Now, so one of the responses that we've received from the government arguing in court, as well as many people, is that marriage is about heterosexual couples who reproduce and as a fundamental building unit of the society. But that ignores the fact that marriage is actually not a static institution. There's a long and existing continuing history of marriage, always evolving as an institution, even as we speak today. So, in fact, these changes are so stark that 100 years ago, your grandparents may not recognize the kinds of families you live in today. Okay, so for example, things like divorce, which was introduced by statute. Adoption is a statutory introduction under Hindu law. Polygamy had to be outlawed by statutory law. Sati and child marriage had to be outlawed. These are all integral aspects of what we call as a traditional Hindu or an Indian family unit. Okay. Adultery has been struck off. Now, adultery brings to the question that people talk about different motivations to marry. There's the respectable answer of, I want to publicly declare my love and seek public acceptance. But there are other motivations to marry as well, one of them being succession to property, and as Chayanika highlighted, the crux of the matter in the Rituparna Bora case being ensuring that you have a freedom of non-interference from state and non-state actors. And you don't need to look into these, you don't need to look at Frederick Engels's Origins of Property and Family to get to this. You can just look at the Supreme Court's own judgment in Joseph Shine on the adultery matter that traces this history of marriage as integrally connected to succession to property. So, and one of the responses to what I just said will probably be that all the examples I shared are illustrations of legislative intervention to effect changes in family, in the marriage. I'll respond to that shortly. So, one of the reasons that the court also observes that marriage is not a fundamental right under the Constitution, which I disagree with, because the distinction between of Asha Ranjan, Shakti Vahini and Shafeen Jahan as being limited to choice of partner vis-a-vis the right to marry your choice of partner it's specious at best. So it shouldn't be very difficult to overrule that. But one of the other interesting reasons given by Justice Chandrachud in the opinion to disagree with marriage as a fundamental right is they look at the Constitution, especially Part 3 and Part 4 of the Constitution, and they notice that not only is marriage not explicitly worded in the Constitution, but it's not material to realize any constitutional goals or aims. So I'll quickly respond to that, saying that we are past a stage where if a legal concept is not explicitly articulated in the Constitution, it means that this is not a fundamental right. The right to privacy case rests that question forever, right? 9 unanimous judges of the court. Secondly, the point about even an implicit reading of the Constitution does not reveal marriage as a fundamental aspect. I would suggest a reading focused on the rights of children under the Constitution, right? Article 15(3) of the Constitution talks about the state's duty to make special measures for children and women. Article 13 specifically talks about state enacting policy or taking measures to ensure health, free development, opportunities, dignity of children, and prevention of moral and material abandonment. Now, the first question that comes to my mind when I read this is that these children are not raising themselves. These children are born in heterosexual married families who are safeguarding these constitutional statutory rights for these children. And in that vein, marriage is a fundamental unit recognized by the Constitution in the limited context over here of protection of children's rights, right? So even that argument, I think, should be responded to. The point on looking at alternative atypical formations of families, while Chayanika has outlined the foundational concepts of where that motivation comes from, it's actually legally also slowly and steadily developing under Indian law. Hijra Gharanas are recognized as family units in terms of succession to property of members who decease, right? That's by at least 2 high courts recognize that. Section 14 of the Mental Health Care Act, if you examine, which authorizes any person who anticipates in a moment of incapacity that a friend, family, or another person should be able to take decisions on their behalf in their best interests of mental health care related medical decision making, talks about the right to nominate any person, right? And now this is not a isolated reading in vacuum of a statutory provision. If you look at the Parliamentary Standing Committee reports of the Mental Health Care Act, this is precisely the intention of the Parliament, recognizing that you want people with mental illness to be able to nominate a complete outsider, stranger, not related by family, blood, by marriage, blood, or adoption, because very often it's these relationships that coerce people with mental illness into abusive, exploitative situations like rehabilitation centers. So the fact that you have a friend who can do caretaking decisions for you is a protection layer against natal family violence. So this understanding is already into Indian law, and which is what this was one of the bases of us seeking a similar replication of the relief for unmarried, single, queer, everybody, not just queer trans people. And in fact, in the last 2 years, there are at least two Ministry of Home Affairs advisories explicitly using the language of chosen families of LGBT people in context of safeguarding rights of LGBT prisoners, right? So chosen families are increasingly being recognized in law and policy, Indian law and policy, to undertake financial, medical, legal, and familial affairs in moments of incapacity. So it's not actually that far-fetched to say that what is now recognized for LGBT prisoners should be recognized for LGBT people generally outside. Just 2 more quick points. On the courts, if you look at the postscript of the judgments of Justice Chandrachud and Justice Bhatt, right? If you look at the postscript of both these judgments, because they are responding to each other, a special focus of their response to each other is on the power of the court to issue directions to fulfill the positive dimension of fundamental rights, meaning that the court is empowered to issue directions to the state to ensure fulfillment and protection of rights, not just to prevent violation of rights, but to also ensure positive fulfillment of rights. This is in context of the directions on civil unions given by Justice Chandrachud, which Justice Bhatt disagrees with. I'll just outline the fact that Justice Bhatt's opinion misapplies, misinterprets at least 3 major precedents in Indian law where, in the absence of legislation, courts have routinely issued directions until a subsequent legislation comes and governs the field. Whether it's in context of sexual harassment law in Vishaka by the Supreme Court in 97, whether it's in the context of transgender rights, which is subsequently followed by a legislation, or much more recently on the question of passive euthanasia, which is again, like, the court has expressed its willingness to even review its earlier judgment and directions and issued subsequent directions. So, of course, the doctrine of separation of powers exists under the Indian Constitution. There is a legislative function, there is a judicial function, but Vishaka, Nalsa and Common Cause attest to the fact that when the legislature is not performing its role, the judiciary is fully vested with the powers to issue directions until a legislation covers the field. The last thing I'll speak on, just briefly, is Justice Bhatt's opinion finds the Special Marriage Act to be constitutionally valid. And he finds it to be particularly constitutionally valid in terms of Articles 14 and 15, which is equality and non-discrimination. One of his key reasonings is that Special Marriage Act is not discriminatory towards LGBT people because it was never intended for LGBT people to begin with. It was intended to cover heterosexual people of different religions and faiths. So the intention of the law is never to cover LGBT people. Now this reasoning, I believe we are beyond this reasoning where you look at what is the formal object or the stated object of the law, because in Maneka Gandhi and R.C. Cooper in the 1970s itself, the Supreme Court has said that you don't look at the formal object of the law, you look at what is the impact, the direct and inevitable effect of the law on the rights of people to determine the validity of a particular statute, which is what we were arguing to say that on this grounds SMA should be read down and reinterpreted. But for the majority court to say that the object of law was never to discriminate, therefore it's valid, it actually overturns more than 50 years of settled jurisprudence. This is not even controversial. I'll close here.
Good. You know, this was supposed to be a non-legal discussion, right? Yeah, but Suraj is an alumnus of Government Law College, and you saw how beautifully he dissected the judgment right down into what was meant. Excellent, Suraj, superb. That was great work. And I also appreciate the fact that you pointed out that it would be the job of the judiciary to discover a fundamental right within the fundamental rights. And there's no way the legislation can discover a fundamental right within, as the judiciary in the past has discovered the right to education or, for example, the privacy within. So you think it was a lost opportunity there for the judiciary to really do its job? And also the point that you brought about that when there's a vacuum, it is a job of the court to fill the vacuum until legislation happens. Maybe in some ways, and maybe you can come back, has the court tried to fill some vacuums in this through the appointment of a committee or whether it is effective or not? And, I know Mr. Raju wants to say something, and so does Abha. I don't know who should I go to, but I'll give, but the ladies get preference over you, sir, yes. So, you know what, Suraj said that the institution of marriage is changing. Now there is widow remarriage, there is sati is gone, dowry is gone, variety. So Shakespeare married Juliet at the age of 14. And in Hindu law, you could marry once a girl reached puberty, and we are talking of the 1900s. We're not even going back way before that. Intercaste, interreligious marriages that were not allowed are now allowed. In Christianity, you got married, you said, till death do us part. In Hinduism, you said, janam janam ka saath hai. So variety of things have changed. Nowadays, ek janam mein teen saath hai. So a lot of things have changed. So at this point in time, why should we not be open? And why does Aqsa have to wait for so much longer before the court or the legislation, for that matter, accepts the fact, creates a structure wherein certain people who are not fitting into the existing law should be given the bundle of rights, because we are not blind to the fact that they are not receiving the rights. If this discussion was 50 years back, we probably were not even sensitive that these rights exist. Today we are sensitive to these rights. If we are aware of this, why should we be denying them these rights, including the discovery of fundamental rights within the framework?
Three of the speakers, I think, have said that marriage as an institution is outdated. So then my query is that if it is an institution which is outdated, then why are we giving it so much importance? Isn't it? Why are we? I think if we don't have, we will be liberating women. Working women who come from office and home and then they have to cook while the husband watches the TV. So, but as my learned friend said, that till death do us apart. I mean, when we were growing up, I think the dictum was कि डोली आती है और अर्थी जाती है. You know, that is what it was. But yes, again, we have moved forward. 3 marriages. I tell all my clients who come to office that don't blow up money on marriages. You will need at least for 2. So that is my unsolicited advice to all the clients who come, that if you're getting your daughter married, or there's nothing called prenup. But if I come to this, that we create a fundamental right to marry. As I said from day one, I don't believe that you can create such rights. And Special Marriage Act actually was there to ensure that interfaith marriages could take place. People from different religions could marry without converting, and it facilitated that beautifully, and even till now it is doing it. You want something new, go to the parliament. And elections are every 5 years. My request is, these young students, your children are so intelligent, so capable, they know the law. So when you have elections, why don't you ask the people who come to ask for vote that this is the law we want, this is the change we want? We can't be running to the Supreme Court and burdening the Supreme Court with only issues which I feel, you know, in fact, in adultery case, I was an intervener in the Joseph Stein case, and what I said was, initially we felt that if a husband can put adultery on the man who's sleeping with his wife, then the wife, why can't wife have the same rights to put an adultery case on the woman who's sleeping with her husband? But it was shocking that the moment this case came up, all the judges said, we are finishing adultery, because I'm sure half the men would have been taken down with once this equality was given. So, you know, so let us not just say that what Supreme Court says, what High Court says, country is going to go by that. It's you and I who you know what is right, what is not right. In fact, in the Sadhguru, I'm little diverting, but because I want to bring that semblance that what you have to go, it is not what just the courts say or what the judges say. In the Sadhguru case, where the father has gone to the court saying, I'm not allowed to see my daughters, habeas corpus, his daughters are adult. Madras High Court said, let the police do the investigation, the inquiry. The Supreme Court comes in the same day, because the brand of lawyers that which Sadhguru can afford, the battery of lawyers that came, and so I'm not taking names, but it takes the case from Madras High Court and says the police investigation is stopped. What did CRPC say? Now it is BNNS, that an IO cannot be stopped, and IO has full freedom of doing an investigation. These are powers of the police. And if there was any one person merit in the complaint of the father who filed the habeas corpus and said that Sadhguru wants his daughter to get married. She is married and living a happy married life, and my 2 daughters he has brainwashed. He has brainwashed my 2 daughters who have taken to monkhood and staying inside the ashram. I need to see them. Is the father right or wrong? Father wrong. Father is wrong that he wants to see his daughters and wants to see that what is happening to his daughters. One of you has said you will have to come and talk to me and tell me why. But the issue is Supreme Court takes up and stops the police investigation. Why are we scared of the police investigation? So issue is you have to see both the sides before coming to a logical conclusion. And that is why we have layers of judiciary. So review petition is there. What happens in review petition, we don't know. It would be what the judge decides that day, because I said even now the Home Minister says and the government says that the adultery law which was struck down was not done in the right earnest. It was a quick decision because the problems which are being faced, where I had come in as an intervener, I said the army wives, the wives of Jawans who stay in separated family quarters for years, the innocent women, they are taken for a ride by wrong people because their husbands are not there. So you have to look into that also. This adultery law was protecting innocent women. Women who were staying away from their husbands for years looking after children, they were being conned. And that time, what was in the mind of the judges, we don't know. They struck it out, and now today the government wants to bring back this change to protect these women. And let me tell you that adultery section striking down has already destroyed marriage. It has finished marriage. As a family lawyer, I see women come and cry. So if it is, you are saying it is, on one side you say it is outdated, then why should I create a fundamental right of marriage? I ask you, my learned friend. Why do I create?
Okay, Abha, that was
One more thing I
wonderful.
wanted to say, what happens to maternity laws? You are asking for 6 months of maternity leave, 1 year of maternity leave because you want to feed the child. In same union marriage, how are these things going to happen? The Advocate General, the Solicitor General said 160 laws need to be changed. I will come back again to my opening statement that look, we are progressive. We have, the courts have struck down 377. Puttaswamy has given you that your sexual orientation is your right. What you do within the four walls of your house is your own personal thing. No cop, no executive can enter that. So let this take time. It is not going to be just put by the court because 5 judges decide and it is done. It is the society, it is the traditions, it is the people who have to change. So to let the change start from you. Elections are there in Maharashtra. Go ask what things you want from the legislature. You are creating, you all also stand up and fight elections. Make the law if what you want. Rather than only going to the court and thinking one pack of judges can decide what is right or wrong, I beg to differ. There are so many judgments I would like to speak against, but then the contempt of court keeps me silent.
Thank you, Abha. That was a great point of view. Though, I may throw a question at you, and tell me which elected government would have decriminalized Section 377. That is really, it would be delusional to think that any government, regardless of which political background it came from, would do that. So some point in time, and maybe over a window, the judiciary has had its ups and downs, but I think over overarching period of time, they have been doing better. Thank you, but I love that spirit. Yeah.
No, okay. I appreciated the 377. I said, we've done it. We are doing it and things will come. But just finishing marriage or talking of laws which have evolved down the years, it takes time. So have patience, my friend.
Okay. So now also one point you mentioned, and I want to throw this question to Mr. Raju, is that the Special Marriage Act, you mentioned in contradiction to what Suraj said. Suraj said the Special Marriage Act could be viewed for same-sex marriage, or have any kind of union, and you kind of disagreed with that. You said the function of the Special Marriage Act was to get people from different religions. So let us say the concept of a civil union, which the courts have not agreed to. Now, a civil union concept was there in Ireland, in France in 1999.
Denmark in 89.
And they migrated to same-sex marriage in the year 2013. It took them about 14 years to go there from civil unions. There are certain states in the US that do recognize civil unions. There are certain private companies that give spousal privileges to people with the civil union. In the UK, a civil union came in 2003. The same-sex marriage was allowed in 2013. Again, a 10-year window. Now, we haven't even started there. So do you think this is something which was, again, a missed opportunity? Do you think the legislation would take on to create a separate structure for people of the same sex, transgenders, etc., to get married?
Professor, before I give a serious response to your question, I had 2 or 3 non-serious responses in the context of comments made by Suraj and Abha. So can we have a light filler before I give a serious answer? Yeah. So one is, of course, when Suraj spoke about the differing approaches of Chief Justice Chandrachud and Justice Ravindra Bhatt on what the court can do and what the court cannot do, I remember two different lessons which two eminent alumni of this college, I don't know if Ashok Desai was, he was a barrister, I don't know whether he studied law here, but I think he did teach here also. Ashok Desai apparently used to tell his juniors, you have to start with the presumption that the judge will be perverse. So you have to start with that argument, with that presumption when you make your arguments. Then secondly, Mr. Nariman told us as young lawyers that if you tell a court that you don't have the power to do something, then the court will roll up its sleeves and says, who says so? We'll tell you, we have the powers. But if you tell a court, lordships have all the powers in the world to do this, then the court says, no, we are not omnipotent, sorry. So these are the two different kind of reactions which you get from courts depending on how you tell them what their powers are. Now, apropos your question, civil unions, yes. Denmark started this in '89. It took time, yes. But that's the point. The court could have at least started with civil unions, declare a right to civil unions, and court lost sight of the fact that law often leads social change and law includes judge-made law. It is when you struck down triple talaq that parliament intervened. Or the other examples which Suraj gave, I'll add one more example. Election Commission. You create a collegium until legislation comes. So what was the big deal about saying that there is a right to form civil unions? And this would be the regimen pending legislation. I think that was the least expected from the court if it was serious about its previous judgments, whether it was Puttaswamy or whether it was 377. And that's where the court not just didn't walk the full mile, it even fell short of half a mile.
But thank you. And exactly like Vishaka. Vishaka was there for 11 years before the POSH Act really came about. Thank you for that, Mr. Raju. I would like to throw a question to Aqsa. Now, Aqsa, you have definitely pointed out a huge vacuum for transgenders in many forums. But if we were to stick to this forum and we take off from a civil union concept, do you have something in mind which you could say, this is something that could work for me? You very clearly told us that the guru-chela relationship is very different. It substitutes the family. So what do you think would you want? What would be your wish list in trying to get this going?
Yeah. First of all, and I would also use this opportunity to maybe, reply to some of the questions that were thrown about that statement on marriage running out its time. Yeah. So I'm not a petitioner in the case. And during the course of the proceedings, I have not spoken on the case. Precisely because, when Abha mentioned कि नहीं चाहिए marriage तो क्यों लड़ रहे हो? So I'm like, I don't want marriage, तो मैं नहीं लड़ रही हूँ. When we say that after 377 what, and we say the next logical step is marriage, I think we are mistaken there. And that view is not the view of the entire LGBTQIA plus community. I, as a trans person and someone who works in the medical field, I feel healthcare rights for the LGBTQIA people are more important. And, Suraj mentioned about the Mental Health Care Act, Chair mentioned about the decision making when you're not able to make decisions. These are things which are very vital to our life, and currently we don't have protection there. There are children who are intersex, on whose bodies surgeries are being performed by plastic surgeons. The children don't know what's happening to them, and these are allowed by the parents because they want their child not to be intersex, only a male or a female child, generally a male child, because our law does not have a provision to write in the birth certificate that the child is intersex. And of course, there is a lack of social acceptance. I would really want what after 377 to talk about gender affirming procedures for the trans people, which are not just on paper, but also provided as a legal right. I would really want for reproductive health rights in terms of surrogacy and ART to be made available to everyone. I'm not a petitioner in the same-sex person's marriage, but I'm a petitioner in the challenge to the Surrogacy Act, which says that only people who have been ever married can go as an intending couple for surrogacy. I would really want that there should be more laws for children who are bullied in schools for their gender affirmation, for LGBTQIA children to be protected in schools, colleges, educational institutes like this. We know that the internal complaints committee are typically restricted to women complainants, and though they have a provision to also include the scope for trans and LGBTQI folks, they generally don't. So, no, after 377, the logical step is not marriage equality. For me, for that, there are many other issues which are there. Second thing I want to say is, and I think Suraj already answered that for me, is that the concept of marriage, which Professor Daswani mentioned in Hinduism, in Islam, and in various Abrahamic faiths, has brick by brick changed. And the marriages that we have today, even within the personal laws, are no longer the same what happened centuries earlier. And therefore, the question which is metaphysical in nature is, if there is a house and if you keep changing a brick, replace with another brick, is that still the same house? So no, we are not doing the marriages which probably happened at the time of Prophet Muhammad, or which happened during the time of what happened in Ramayana and Mahabharata, where people could have 100 wives. You are not allowed to do that today, right? So it's not the same marriage. And well, I wouldn't say that, those who want to get married shouldn't be allowed to get married. That would be a very weird statement. Yes, people should be allowed to get married and ruin their lives if they want to. Fortunately, in our country, if people want to die by suicide, and trigger warning here, we allow that, right? It's not a crime. Then why should marrying be a crime? Yes, please go ahead and do what you want to do with your lives. And I think a very important solution in the personal laws would be to make divorce simpler. Just as how marriage is very simple, you can just go to a temple or a mosque and get married. Probably, I think making the divorce simple would ease the job of Abhaji a lot in the family courts. There was a statement made in the morning that probably when you allow same-sex marriages, it will lead to chaos. I don't know if the riots will break out on the streets because of that. But then the same fear was there when we talked about interfaith marriages. Oh, what will happen when, Muslim and a Hindu will get married? How will their children be raised? Which religion will they follow? Will the son be circumcised or not? What will be the name chosen? And when they die, whether it will be burial or whether it will be cremation. But Special Marriage Act is there. There are thousands and thousands of interfaith couples, and there is no chaos, which is there. In fact, all there is a chaos which is done, it's by the politicians and their agendas with words like love jihad. I have been often told this, not just in this forum, but everywhere, to go to the parliament. But the doors of the parliament are locked for me. It's been more than 7 decades, and there has not been a single transgender parliamentarian in our country. From thousands and thousands have occupied those seats. We give reservation for Anglo-Indians, saying, oh, they're a minority, we need to give them a voice. But what about the minority of trans people? There is not even a single person in Lok Sabha or Rajya Sabha. And if everyone has an equal opportunity to really go and fight elections, why are we even talking about women's reservation in parliament? I'm sure women are very competent enough to fight elections and reach parliament. Then why should we talk about women's reservation in parliament? And if we are talking about women's reservation in parliament, then why there should be no nomination or reservation for transgender people in parliaments if you really want my voice to be heard? Because the people who enacted the Transgender Persons Act, none of them was an out and proud transgender persons. And I don't really want my lives, to be governed by the rules which are made by cisgender people. I want to become a parliamentarian. Please send me if someone is listening. Coming to a comment which was made on maternity laws and, women have to breastfeed and therefore they need 6 months. We currently do have provisions for fostering. And, the benefits of maternity leaves being provided to couples who are fostering, couples who have adopted. And there are many, many countries across the world who have same-sex couples and to whom paternity leaves or parental leaves are made available. And I think it's also important to learn from those lessons because the societies are going to evolve. When we say you can live together and you can also adopt as a single parent, they will have children. Is it right then to deny them the leaves for taking care of those children just because they don't have a marriage certificate or choose not to have a marriage certificate?
Thank you, Aqsa. Thank you very much. Thank you very much for bringing a lot of things on the table here, which I'm sure the audience here would be definitely enlightened and probably made aware. I mean, we probably know this, but I think this really makes us aware, straight up front on the things. Though I just want to, put in one comment here. And you did mention that you're changing brick by brick. So I guess when you change a house brick by brick, it will take time, as our Abha said. And the change and the time, it's not a top-down. It has to come from society in terms of acceptability. I guess that would be something which, it's a pain that we have to live with, I'm saying. Chayanika, you spoke about the ability to choose your own partner, to have your own partner, to independent of your family, the person who's going to be your guardian, etc. Now, and also that partner is going to be probably in an intense relationship with you. Now, I'm putting one of the things that was said by the authors is that if I permit unions without any safeguard in place, would that create a different danger? Would that be going down a slippery slope when there would be, people engaging in incestuous relationships? And it would in fact cause a disruption to the other people who are engaging with them. And that would probably lead to greater discrimination. So the ability to form a union, do you think there should be some regulation or it should be a full freedom to choose what you want to do?
I think the question is kind of, not your question, but what was said. Marriage is also not without restrictions, right? There are restrictions, we may agree with them, disagree with them, but there are restrictions. Similarly, if you actually regularized a relationship, in whatever manner that you wanted to, you could put restrictions. It's not impossible to put restrictions. By what the court has in fact done is said, make yourself vulnerable. Go and live with who you want. The court is saying that to us, right? It is saying that you can live with who you want. There is no restriction. So actually, the protection that people are asking, it has in fact given away. It is saying that in a way, it is strange because it thinks that queer trans people are very matured, sorted people, that they'll make good relationships. They don't need protection from family. They don't need protection from law. They don't need protection from society. They're all wonderful human beings. They will live their families without any domestic discord. They will not do anything wrong to each other, right? This is what the court is saying. Because when it comes to a straight man and a straight woman, if they say, and I come back to the comment that I said in my opening remarks, if a cis man and a cis woman want to live with each other, raise your hands here. How many of your society people or friends, family, community will accept it? And how many of them will say, so how many of your friends, family will accept if you say, I don't want to get married. I'm going to live with this person. Nobody. Okay. So the thing is that we are so protective of heterosexual marriage.
Yes.
We want to keep it intact.
And you want to
We want to keep it intact. We want to keep its structures there. We want to maintain its sacrosanct character.
Yeah,
We want to do all that while accommodating for differences, while accommodating for different bricks that have come in, but we don't want to disturb the structure of this institution. And I think as a person who looks at society at large and looks at social structures, I think caste and patriarchy are the structures that control family. And I do not agree of both these structures. So in that sense, I feel that marriage is an outdated institution. It doesn't have to be, but it does not mean why I still argue for it. Because there is no other recognition in law. There is no other recognition in state policy. They don't recognize anything else. And if you do not recognize anything else, then I am deprived of those rights. And that's why I have to come back to the institution. Not because I want the institution, but because the society, law, and state are not ready to give up the institution. That the only other way that you can deal with it, the only other way that a fair social legal system can work is by actually making it equitable. That's the only way that it can work if it cannot deal with these other contradictions within the institution itself. So that's what we were trying to do. And I think by not even giving, I'm not a lawyer, so I'll take this liberty. Civil unions with equal rights is what one would have asked for. I don't know what Special Marriage Act is then. Special Marriage Act is a civil union. It doesn't follow any religion. It doesn't follow any faith. It is a civil union act. So I don't know what the court could have done in terms of saying, okay, we'll give you a civil union, name different, right? But all the rights that are there within that, so fine. I mean, if that is what, if in my interpretation, the Special Marriage Act is already a civil union. When countries like Denmark started, all of them started with not giving adoption rights. All of them started, I mean, there's this long-held belief that so-called sexual deviants are very dangerous to children, right? Teachers should not be queer people. Queer people will not bring up normal children, so on and so forth. We've heard this all the time. So adoption was the last right that every other country gave to when it granted same-sex unions. I've been a feminist and a women's movements activist prior to and alongside a queer activist. I think violent families are very, very detrimental. Violent marriages are very, very harmful to children. We don't want to disturb that. We are thinking of imaginations, of unions which are made out of choice and love. To be detrimental to young people, I do not understand where these people are coming from. Because they come from, and I'll tell you what my guess is. They come from the fact that they think that same-gender people or queer trans people are out there for sex. They're not there for relationships and love. This is their presumption. And I think that is also underlying, and that's very, very discriminatory. It's very, very discriminatory. It insults all of us.
One more thing I can add here is the DV Act. The DV Act also says if in a relationship like marriage, if you've lived for long enough, maintenance, alimony, maintenance at least interim, you get under the DV Act even though you're not married. So, no, but I think, but what I'm trying to say is that at least now we are accepting if you're living together. You know, the courts have moved a little, saying that if you're living together.
That's why I said that we're protecting marriage and protecting heterosexuality.
So, no, I would say a country like this where it was unheard of a live-in relationship that you said just two hands went up saying that my parents would agree. But at least the courts have moved forward. And that civil union is something which would come in the long run because insurance, spousal benefits, those things need to be given because if two people are living, another issue, so South Korea just went in and the court ordered because the partner of the same-sex union, the other partner was to get the insurance benefits. So I think long run we will have, but today is not the time. The debate, of course, I would really appreciate and I would congratulate this debating society and the faculty for having this relevant topic because it will definitely make us think about it, talk about it, and I think we are convinced that this will come, but not today, but in the long run.
Yeah, I think, yes. And, the point that, Chayanika and you both have raised is that, we are literally tolerating you by allowing you live in. And we are definitely not going to protect you the same way we protect, a heterosexual marriage. And some of those people who put up their hand, they said they will live in. They didn't say their parents will agree. Yeah, I have got strong doubts about that one, yes.
How many parents will agree now? Lift your hands.
See?
Abha saying in the long run, just a quick comment. In the long run, says Abha. The famous economist Keynes, John Maynard Keynes said, in the long run, we are all dead.
Absolutely.
That's the Supreme Court. Apex Court. Voice from the Supreme Court.
Okay, to tell the audience here, please be ready with your questions. I'm going to throw one last question at Suraj, and probably you can comment on all what you have heard.
Some lunch also.
Lunch? Okay. Right. So, Suraj, I want to throw the question of adoption that has come in. A single person can adopt in India now. But if he is a gay couple, he cannot. Now, taking what Chayanika said, that it is assumed that gay parents are, going to be bad parents. Is there a concept whereas the child tomorrow would say that I was adopted by gay parents and that's something I did not want? There's a school of thought that says the child may tomorrow grow up and say that, So I'm playing the devil's advocate here by asking you, should adoption rights, if they're given to a single person, if they're given to married people, why should it not be given to two persons who are, of the same gender or even transgender, and they are in a live-in relationship, whether married or not? So the whole idea, because as you pointed out very nicely, that having a child is one of the key requirements of human fulfillment of a human being. Yeah, you read Article 15, etc. Yeah, that's just taking off from there. Yeah, but you, sorry, that's so you get what I mean. So how would you deal with adoption and the marriage equality or even live-in relationships?
It's the CARA guidelines under the Juvenile Justice Act that govern the question of adoption and who are considered eligible parties. In terms of a marital relationship, it's obviously a heterosexual couple, and single people are allowed to adopt, whether gay or heterosexual. But there's a circular by CARA now saying that if the quote-unquote single person is in a live-in relationship, in a non-marital relationship with another person, then such parties are disqualified from adoption, which is exactly what one of the issues was argued before the court. Now, to your question about if a minor is given up in adoption to a queer LGBT family, married or unmarried, and whether the child, after growing up, chooses to emancipate themselves because they don't believe that this is their best. I mean, but that question would apply to a child in any family. Even in an abusive heterosexual family, children should have the right to claim protection, safety, well-being, moral and material abandonment, as the Constitution says. That applies equally in a heterosexual abusive family or a queer family, even in context. And again, to play devil's advocate, because I've been asked this question in workshops earlier, that don't you think you would be endangering children from their peers and their social environments? Because children of queer trans families would be bullied for having queer trans parents. And my response to that has been, but there have been intercaste, interfaith children in schools for generations, and of course those children do face bullying and abuse and violence perhaps also. But the response to that is not that you should repeal the Special Marriage Act or prohibit interfaith, intercaste marriages. The response to that is that you need to sensitize and train children, teachers, educational institutions and society at large to be accepting of religious diversity, harmony, plurality. And qualitatively that same logic would apply for ensuring that children of queer trans families do merit the same kind of protection by sensitizing, training universities, academic institutions on diversity of gender, sexuality and human rights concerns of LGBT people. Does that answer your question?
Yes, I'll now throw it to the audience about questions. Please stand up, say your name, and tell which panelist you want to address. We are thinking of winding up in about 5 or 7 minutes, so we'll take 2 or 3 questions. Anybody? Yes.
Namaskar. Can I talk in Hindi? मैं ये कहना चाहता था कि प्रकाश रघुनाथ चौहान।
और आप कौन से पैनलिस्ट से क्वेश्चन पूछ रहे हो?
वो जो कह रहे थे कि फंडामेंटल राइट, मैरिज इज अ फंडामेंटल राइट। हाँ, मैं ये कहना चाहता हूँ मैरिज, आई डोंट नो, मे बी विल बी फंडामेंटल राइट और नॉट, बट फंडामेंटल ड्यूटी तो होना चाहिए कम से कम। अगर हमारे देश को बचाना है तो ड्यूटी तो होना चाहिए। आजकल हम में से बहुत सारे, दुनिया में बहुत सारे, कि वो शादी ही नहीं करना चाहते हैं और लड़के भी नहीं चाहते। ड्यूटी बनाओ फंडामेंटल। वो हाँ, वो बाइंडिंग नहीं है ड्यूटी, आर्टिकल फंडामेंटल ड्यूटी बनाओ कम से कम।
तो ये आपका रिकमेंडेशन है?
हाँ, रिकमेंडेशन। और हमारे जो और
आप जरा क्वेश्चन पूछिए तो मेहरबानी होगी।
नहीं, यही तो क्वेश्चन है कि फंडामेंटल ड्यूटी चाहिए।
हाँ, कम से कम फंडामेंटल ड्यूटी तो बनाओ, ये भी है। और
नहीं, वैसे हम पार्लियामेंट नहीं है इधर।
अभी आपने
लेकिन उसके लिए डिस्कशन तो बनाओ। और हमारे जो धर्म जो कहते हैं उसमें हम मैरिज को ड्यूटी कहते हैं कि बाबा मैरिज करो, ये तुम्हारी ड्यूटी है, अपने परिवार को बढ़ाओ, ये तुम्हारी ड्यूटी, परिवार को बढ़ाना तुम्हारी ड्यूटी है, समाज को बढ़ाना तुम्हारी ड्यूटी है, इसलिए मैरिज करो।
ओके।
और ये भी था कि हाँ, मैरिज आपने कहा कि हिंदुइज्म में मैरिज 3 चीज़ों से किया जाता है कि बाबा धर्म, प्रजा के लिए और सेक्स के लिए। लव इज इम्पोर्टेंट, आई थिंक। मैरिज do marriage for love.
Thank you very much. Yeah. Whoever gets the mic, yeah, go ahead there.
Right, hello. So I'm Sarthak.
Yeah.
My question is to all the panelists because I want to engage with the Supreme Court judgment itself. Now the judgment, Ravindra Bhatt, Chandrachud, all of them come up with apocryphal reasons. For example, one example, marriage predates the state itself. So therefore, we can't control marriage as an institution. Now, I can say that for the right to environment also. The environment predates the state. So is it an institutional abstention by the Supreme Court by saying that it is not in our control? And what more? Let's forget about the prayers. What more, if at all anything, at the bare minimum, should the Supreme Court have done?
It is not just abstention, it is abdication. It is abdication, and even this statement that marriage predates the state, I think that's questionable. What is the evidence to say that marriage, what predates the state is Adam and Eve, love, sex, they predate the state. But from where does the court get this that the institution of marriage predates the state, then who else gives recognition to the institution of marriage and all that follows from it other than the state? So it is based on questionable assumptions, and yes, it is judicial abdication.
Can I add one thing? So just on the point of a particular phenomena or institution predating the state, therefore the judiciary or executive's apparent inability to regulate that phenomena, caste predates the state, right? But Article 17 of the Constitution outlaws untouchability. You have several legislations that specially focus on rights of caste-based minorities, prevention of violence and other aspects. So I don't think that's a coherent argument to avoid regulation, right? Because marriage, all incidents of marriage are legally performed, child custody, divorce, maintenance, these are all formal legal institutions that regulate and govern all these institutions. So just to call something a social institution, therefore immune from legal regulation, doesn't make sense, because those social institutions are inextricably embedded in your constitutional and statutory and executive frameworks.
Good afternoon. My question is for Aqsa, ma'am. So my question to you is, you went ahead and said that you don't want the union or marriage to be there, but for same-sex couples. But you also said that people who want to get married, same-sex couples, should be allowed to do so. So my question to you is, unless we go ahead and get the state to recognize same-sex legal union, how would we go ahead? See, if it is legalized and the fundamental right is given, it's not a duty that the state is going to go ahead and say, now you have to marry. But at least that option should be made available to the people, and for that, we'll have to go ahead and recognize that it is in a way a fundamental right. People who want to go ahead and avail it, that option can be availed by them. So that is my question to you.
Thank you for explaining very clearly what I meant. I think I might have been misinterpreted. No, I'm not against queer people going to the court asking for marriage equality. I totally support that. I was saying that we should, in a larger run, debate about the institution of marriage. And Chair very nicely answered that we don't have an option in the current times that there is some other institution available. So we have to go through the process of asking for legality of marriage and civil unions to get those bouquet of rights and protection. And I absolutely agree over that. But my perspective is to also look at other forms of family building. And in the longer run, to think about, is marriage really necessary, and should there be so much pressure on people to get married, and if that should be the only option. I'll give a parallel example. If suppose I want to become an advocate, there is a process. The important thing is learning the law. The important thing is not really getting into a college, paying fees and going through so many semesters, internships, etc. and doing that. But then there's no other option for me to study law other than going through that process. So whether I like it or not, I have to follow it. So similarly, queer people right now do not have any other option than to go and ask for relief from the court through recognition of their unions or
I must
marriages.
pause you there. A round of applause for Aqsa. She just told all of you what you should do. Don't clear the LLB, please learn the law. Yes, thank you. Thank you so much. Thank you so much. Sorry, please continue. That was wonderful. Thank you so much. Yeah. I mean, what is activists are being lawyers, activists are becoming teachers. I don't know what's happening on this panel. Yes. Any other question? Yeah.
Hi, a very good afternoon. My name is Medha and I have a very simple question. We've talked about civil unions quite a bit, but if one of the panelists could just explain that what would my rights under a civil union be, and how is it going to be different from, let's say, a conventional marriage? how is it even going to be different in the first place from the associations that we have currently? And how is it going to be different from marriages in general?
So I actually do not think there will be any difference if we are equal. Now, you could give civil unions with lesser rights. You could give civil unions that allow for people to register and then do some sort of holding property together, some provisions around property. Maybe no adoption allowed if you're in a civil union, and so on and so forth. So you would be, there is a hierarchy that we are creating. There are live-in relationships, which are very immoral, right? And I'm speaking of this in the eye of law. There are live-in relationships, and then there would be civil unions, and then there would be marriage. This hierarchy today exists between marriage and live-in relationships, that we are now at least recognizing violence in heterosexual live-in relationships, which seems like a step forward. But we're not recognizing any other rights, right? So the thing is that this hierarchy of relationships, I think the court shied away from doing that. It did not want to create a hierarchy of relationships. If it said, okay, we give civil union with full rights, I think many of you would choose civil union. Because then the restrictions that marriage has, the restrictions that civil unions have might be different. In my imagination, in a marriage, because it's between a man and a woman as it exists today, women's rights are protected in certain ways, right? So you put in laws, there are laws that protect the weaker person in the relationship. Many of us might think that my relationship does not require that protection. I am equal to the person that I'm living with, and I want to get into an equal relationship. So I don't want the protections that the marriage laws give. I want to get into a civil union with somebody. Civil union might mean that we will do sharing of property. So whatever property I come in with, whatever property you come in with, it stays yours. What we build together is shared. There can be multiple ways in which we can imagine them. So it will necessarily preclude marriage today, and that is one of the things I would say why marriage would not automatically expand to all genders, is because marriage law today in India and otherwise has progressed with the knowledge that the husband and the wife are not equals. Right? So then they're unequal partners in a relationship. And there's protection for the wife in that case. So introducing two equal partners in that case into a marriage would be a problem. So you could make civil unions which would have equality as the basis, and anybody could go in for it.
See, like there was a Supreme Court judgment where in a maintenance case, the bench said that if the husband, because we definitely agree that husband is the provider, the man is the provider. They said if he is able-limbed, if he has hand and feet, he better work as a laborer but provide for his wife. So that kind of protection is given to the wife. So definitely in this same-sex union, you'll have to also decide who's the stronger, who will provide the maintenance, who will be maintained, or what you talked of that you come with your property, that is prenup. We with family law are fighting that let us have prenup, at least so many divorce cases will finish, so many ugly divorces will not happen. So the parliament needs to move towards getting a prenup, which is world over, but in India we don't have. So there are so many things we don't have. So crux is that we need to have policy debates more often so that we start thinking.
There's one more thing I want to add to this. Civil union is not something which is defined. So therefore, the civil union of Denmark may not be the same thing as the civil union of Norway. So if the Supreme Court had declared the right to form a civil union, it would have still meant that there had to be legislation to formalize what that civil union would entail, what it would not entail. So the legislature, apropos your question, that how is it different from marriage? It was for the legislature then to decide whether it is marriage for all purposes, or it's level 2 marriage, or it's marriage light, all those, but all that was for the legislature to decide. But the Supreme Court had to at least enable the creation, and in fact, court can't compel legislation, yes. But that also is something which is said in the air. You ask them to create a framework, say until legislation, then court lays down guidelines till legislation comes into force. The court can then prescribe what is fair. If the legislature disagrees, it's a different matter. But the court ought to have created a structure.
I just had a small point to what Mr. Ramachandran already said. So of course the code doesn't clarify how would civil unions be qualitatively different from the institution of marriage, but both in Justice Chandrachud and Bhatt's opinions, where they've issued instructions to the central government to constitute a committee and undertake certain, if not legislative, but administrative amendments to policies to ensure that non-marital lesbian, gay families are protected. They talk about things like coverage under income tax laws, family benefits, employment benefits, things like that. Yeah, but some of these meetings have happened by the government departments, and it's clear that they're only limited to only administrative changes in laws. So it's not going to trickle into, say, amendment of the Juvenile Justice Act, which would then top-down dictate that, yes, lesbian, gay, trans people, whether single or jointly, can adopt children. Because that's not going to happen with just an administrative notification, which can't go against the parent statute. So there are limitations.
Okay, thank you. I'm afraid it's past 2 o'clock. We do not have time for any more questions, and I'd really, like to thank my speakers for giving us so much information and so much enlightenment out there. And this concept of marriage equality, you must remember, is not an urban concept. In fact, there are people in rural India who have actually married.
I represented 2 people, and that's the perspective. Sorry, just one more line. Because the central government filed a totally gratuitous affidavit saying this is a phenomenon confined to the urban elite. My petition showed that this was demonstrably wrong, because the 2 partners in my petition were a Dalit woman and an OBC woman from UP and Haryana. And so it was not an urban phenomenon at all.
Love is universal.
Yes, and I'm going to finish today's. Can I request everybody to sit down? We're just about 2 minutes away from closing. I'd like to share something with you, one that I heard from a priest. He said, marriage is a union of 2 spirits, and the spirit is neither male nor female. And the last line would be from an Urdu poet. It says, Ishq par zor nahi, ishq par zor nahi hai ye wo atish galib ki lagaye na lage aur bujaye na bane. Thank you.
Thank you.
Thank you.
Thank you.
Thank you all for your patience.
We keep sitting.
This was truly a scintillating debate. I would like to extend my heartfelt gratitude on behalf of Government Law College to all the panelists for engaging with us and enlightening us on ideas and policy issues regarding marriage equality and the future of same-sex unions in India.
The debate has highlighted the importance of various aspects raised by each panelist. We duly appreciate each insight that they have provided us with. We thank Senior Advocate Raju Ramachandran for his in-depth analysis of same-sex judgment and explanation of Special Marriage Act. We are really grateful to Advocate Suraj Sanap for his insights on Mental Health Care Act and the powers of the judiciary to issue directions in absence of legislative actions to affirm persons' rights. We sincerely appreciate Chayanika Shah for highlighting Rituparna Bohra case and the issue of estranged relations with the family and their choice to decide for themselves. We also express our gratitude to advocate Abha Singh for pointing out the need for slow progress in greater public perception and her analysis of marriage equality's effect on adultery law, maternity law, and DV Act. Lastly, we thank Aqsa Shaikh for her insights on deficits of Trans Persons Rights Act, especially the lack of mention of conjugal rights, and her call for gender affirmation and medical rights for trans persons. Her question of the institutions of marriage and traditional family units were very much appreciated.
The debate has highlighted the importance of various perspectives in shaping the future for society. It underscored the significance of inclusive dialogue and thoughtful deliberation in addressing the complexities of such pivotal issues. The insights shared today have not only broadened our understanding, but also emphasized the need for continued discourse as we navigate the evolving landscape of equality, justice, and human rights. We leave this discussion with much to reflect on and with renewed hope for a future built on fairness and compassion.
In conjunction with our event, the Debating and Literary Society organizes the Policy Review, a competitive call for articles, opinions, and essays on the themes of the debate, giving an opportunity to the students across the country to write about their policy perspectives. This year, students were given the opportunity to write on 5 interesting topics: navigating marriage equality through the frame of personal laws, recognition of same-sex marriage, a question of conjugal rights, adoption, parenthood, a right or a privilege, beyond gender, the importance of gender-neutral domestic violence laws, modern perspective on inheritance laws, adaptation to same-sex unions. However, owing to the large number of entries, much more than we had expected, we have prolonged the judgment process in the interest of a fair and assessed verdict. We usually announce the same at the policy debate, but this time around, all the participants will be notified of this result online by the Debating and Literary Society very soon. We thank all the participants for making the policy review grow with every subsequent edition. Keep writing, we encourage more participation, and we are ever grateful for the growth we have seen thanks to you all.
We gather here not only to mark the end of the 9th edition of the policy debate, but also to pay tribute to a distinguished panel of individuals whose presence has enriched this event. It is with great pleasure and immense pride that we come together to felicitate our esteemed panelists. I would like to invite Advocate Suraj Sanap to receive a token of appreciation and our co-convener Riya Narkar to present the same.
Now, I would like to invite Senior Advocate Raju Ramachandran to receive the token of appreciation and our co-convener Aryan Gurav to present the same.
After the felicitation is done, I think we have to close the window or something. No, vote of thanks. I would like to invite Ms. Chayanika Shah to receive the token of appreciation and our Deputy Convener Vakar Vasta to present the same.
And lastly, I would like to invite Advocate Abha Singh to receive the token of appreciation and our co-convener Riya Narkar to present the same.
Please join me in welcoming our moderator, Professor Kishu Daswani, to receive a small token of appreciation, and our co-convener, Aryan Gaurav, to present the same. Thank you, sir, for being our mentor and guiding us throughout.
Thank you, panel, for being a part of this event and for making the 9th edition of the policy debate a truly unforgettable experience. Please join me in a round of applause to celebrate this fantastic panel. We would now like to call upon our convener, Riya Narkar, to present the vote of thanks.
Hello. Good afternoon, everyone. As we come to the close of the 9th annual policy debate, it's my privilege to extend a heartfelt vote of thanks on the behalf of the entire organizing team. First and foremost, our heartfelt gratitude extends to the true stars of today's event, our esteemed panelists, Dr. Aqsa Shaikh, Advocate Abha Singh, Advocate Raju Ramachandran, Dr. Chayanika Shah, and Advocate Suraj Sanap. Thank you for gracing us with your time, wisdom, and insights. Your presence has elevated the event, and we are sincerely honored by your participation. We also express our deepest gratitude to our chief guest, Justice S.C. Dharmadhikari. Your presence and insights added immense value to the event, and we sincerely thank you for your time and wisdom. An event of this scale is never possible without the support of many individuals. To begin, we would like to extend our sincerest appreciation to our principal, Dr. Srimati Asmita Vaidya, whose guidance and support have been instrumental in ensuring the success of this debate. She's not here, but thank you, ma'am, for your unwavering encouragement. We would also like to express our deepest gratitude to our moderator, mentor, everything, Mr. Kishu Daswani. Not only have you consistently agreed to moderate this debate year after year, but your invaluable mentorship and guidance have helped us navigate moments of uncertainty. Sir, this event would not have been the same without you. A special thank you to our professors in charge, Anita Desley ma'am and Shweta Siraskar ma'am. Your support throughout this journey has been our guiding light. We are forever grateful for you to be present with us. At this moment, I would like to take a pause and truly reflect on the journey that has led us here. Organizing this debate has been a labor of love, filled with late nights, brainstorming sessions, and moments of uncertainty. But through it all, what kept us going was a deep belief in the constitutional value for meaningful dialogue. To everyone who contributed their time and effort, a heart to this event, the success is yours. We are not just a team, but a family, and I feel truly blessed to have walked this path with all of you. A heartfelt thanks goes to Mr. Mario, who is an activist and historian, Mr. Raghu Karnad, and Mr. Shivam Kakaria for their invaluable guidance throughout the research process. There are certain people without whose constant support and love our vision for this successful event would have never fructified. Taking a minute to thank them for constantly being here through all our nagging and constant disturbance, we would like to thank Jadav Kaka, Ajit Kaka, and the whole administrative staff of our college for their cooperation and assistance. I would also like to thank the advisory board of the Debating and Literary Society. Dhanashri Dalvi, Ram Manohar Gupta, Siddhant Paithankar, and Shwet Pandit. And our alumni, Pranav Kagalkar. They are the pillars of our community, and it is their guidance and love that motivates us to do what we do. We wish to express our deepest gratitude to our goodwill sponsor, Lex Services, whose unwavering support has been instrumental in making this event a reality. Your contribution has enabled us to create a platform for meaningful dialogue and exchange of ideas. We are truly grateful for your generosity.
A big thank you to our media partner, SCC Online, for amplifying our voice and ensuring that today's discussion reaches a wider audience. Your partnership has been valuable, and we immensely appreciate your role in bringing this event to life. And to the Executive Council of the Debating and Literary Society, my fellow convener Aryan Gurav, our deputy conveners Raj, Singh and Vakar, Vasta. Thank you for your dedication, hard work, collaboration. It has been a pleasure to organize this event with you. We would also like to acknowledge our junior council, Anushka Patrikar, Harshal Dorkhande, Harshita Damani, Khushi Jain, Lavanya Mahajan, Manasvi Chaudhary, Neerja Pore, Riya Kulkarni, Sanjot Umbra Jakar, Shivam Shaurya, Tapasya Narvekar, Tirtha Mohite, and Vaishnavi Shravas. This is the biggest core we've had. They have played an integral role in organizing this event. Lastly, but not certainly least, a heartfelt thank you to all our members, volunteers, and each and every one of you present here today. Your participation is what makes this event meaningful, and we look forward to seeing you next year for the 10th edition of the policy debate. Thank you all, and have a wonderful day ahead.
I request everyone to please rise for the state song and the national anthem.
सह्याद्रीचा सिंह गर्जतो शिवशंभू राजा दरी दरीतून नाद गुंजला महाराष्ट्र माझा जय महाराष्ट्र माझा गर्जा महाराष्ट्र माझा काळ्या छातीवरी कोरली अभिमानाची लेणी शिजला विठ्ठलाच्या घामाने भिजला देश गौरवासाठी झिजला दिल्लीचेही दत्तराणी महाराष्ट्र माझा जय महाराष्ट्र माझा गर्जा महाराष्ट्र माझा जय जय महाराष्ट्र माझा जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे